Let's take a look at the use of criminal records in background checks. One of the clearest indications that a prospective employee might be unfit for a position is a history of criminal activity. Failing to check for criminal records is probably the surest route to negligent hiring. However, legal issues affect both access to information about criminal histories and the use of that information. Conviction information is not always available and should not be used to exclude all persons with criminal histories from hire. It's important to realize that the number of people in the United States who would have been convicted of crimes is large. The United States imprisons far more people than any other country in the world. With 5% of the world's population, the United States has nearly 25% of the world's prisoners. Approximately 700,000 persons are released from jail each year. It's estimated that a quarter of all adults have had some type of criminal history. At the same time, more than 90% of employers conduct criminal background checks for at least some of their positions. Policies limiting employment based on criminal histories stand to affect significant numbers of people. It's important to distinguish between arrests and convictions. Individuals are arrested and are often released without actually being charged. They might be picked up for questioning, mistaken for someone else, or a number of other reasons. The U.S. system of law operates on the presumption that persons accused of crimes are innocent until proven guilty. Thus, an arrest cannot be presumed to say anything valid about a person's character or fitness for employment. By comparison, a conviction for a crime, following either a trial or a guilty plea, is stronger evidence of lack of fitness, but crimes differ greatly in their severity. Felonies are more serious crimes for which imprisonment of more than a year in state or federal prison may be imposed. Misdemeanors are less serious criminal offenses that may be punished by a fine or imprisonment of up to 1 year, usually in a county facility. Conviction records, unless sealed or expunged, are public records and theoretically accessible. However, states sometimes have laws that limit access to this information and allow people to apply for jobs without revealing their criminal history. Law enforcement agencies do not routinely make their comprehensive national databases available to employers. Moreover, retrieving information about convictions is not as simple as just logging onto the internet. Criminal records have been shown to be incomplete and inaccurate in many cases. Many employers avoid dealing directly with these problems by contracting background screening companies or private investigators. Regardless of who assumes the responsibility of checking for criminal convictions, the comprehensiveness of the search is an important factor. A search limited to a single state or a brief period might not yield the relevant information. If criminal history indicates unfitness for positions where there's foreseeability of harm to others, both the threat of negligent hiring suits and the basic ethics clearly dictate that unfit candidates should not be hired. However, problems arise when employers overreact to this legitimate concern by seeking to exclude anyone with prior criminal conviction, or worse, anyone who's been arrested. Overly exclusionary criminal history policies have been successfully challenged based on their disparate impact.